consideration and then subsequently for passing by this House.
Kumari Sushmita Dev.
Honourable Deputy Speaker, sir, the bill that this government has moved today, the Public Premises Eviction of Unauthorized Occupants Amendment Bill 2014, is a significant bill, and as the Honourable Minister has stated in his opening statement, that this bill had been moved by the UPA government in 2011. Thereafter, it was referred to the Standing Committee, which gave its report in May 2012. And what this bill seeks to do is take on board the recommendations of the Standing Committee as proposed in the Lok Sabha. Significantly, this bill goes beyond what the Standing Committee said and the earlier Act of 2011, in that it makes changes in Section 4, 5, 7 and 9, which are procedural, which sets strict deadlines for the estate officer and for the person to whom a notice has been issued, a notice of show cause. Amendments to Section 2(2)(e), subsection 1, subsection 3, subsection 4, subsection 5, I would say are necessary in light of the New Companies Act 2013 and the proposed amendment to the Major Ports Trust Act 2013. Significantly, the request that was made to the UPA government by the Delhi Metropolitan Railway Corporation to include their properties as public premises has also been taken into consideration in this. I think it is a good move in the right direction, because the fact is that it is a settled principle that public purpose must supersede private interest. Therefore, we support this bill. Section 2(3), subsection 1 is seeking to look into an anomaly that was raised in a writ petition in 9644 of 2007. That is also welcome, because the High Court had actually rejected that PIL, and this bill looks after that. Deputy Speaker, sir, it is the law of the land that the government always acts in greater public interest, and therefore this Act, this 1971 Act, gives the Government of India, a state government or any government-owned company, be it by the central government or the state government, it gives it a privilege that it need not go to a court of first instance and undergo the rigors of a civil court. In greater public interest, it is a mechanism that is provided to the government in view of the fact that the government is today going to remove an unauthorized occupant and use that land or building in greater public interest. I appreciate that, I understand that, and I would like to move from there on to the Supreme Court judgment which was passed in 2013. Very briefly, I will say that that case was dealing with a government employee who was a driver who had been transferred, and he has refused to leave his accommodation because he filed in the tribunal a stay order against his transfer order. The judgment is clearly dealing with government accommodation. In that judgment itself, the opening lines were about people, about affluent people who continue to stay in government accommodation, be it employees, be it public representatives, be it honorable judges of various courts, and therefore the court appointed an amicus curiae, I think it was Sri Ranjit Kumar, who gave his suggestions. Not only the Union of India, but various state governments also gave their suggestions, on the basis of which the Supreme Court gave some 18 or 20 suggestions. This bill seeks to address those issues. But there are certain issues that I would like this government to consider in this bill vis-a-vis the amendments that have been made in section 4, 5, 7 and 9. The net effect of it is what? That from the day he issues a notice till the day an eviction order is passed, he is given approximately, I think, 13 days and 30 days. And under compelling circumstances, he can increase it by another 15 days. But the Supreme Court also in this judgment is saying that while you follow this procedure, you must stick to the rules of natural justice. So effectively what is happening? Effectively what is happening that from the date of notice to the order which you are asking him to give in 15 days and a reply within 10 days from the date of notice, you are forcing the estate officer to consider evidence and the reply to the show cause notice within 7 days. Because 10 days from the date of notice I give my reply, within 15 days you are asking me to give me the order. Under section 9 of the Act, the estate officer has powers under the Code of Civil Procedure where he can summon a witness, he can examine a witness, he can today look into documents and therefore has the power to go into questions of fact. Now I ask this government that today where section 2 is saying that what is premises? Premises is today not just a building. Today when you talk of a premises, you cannot just think of a public representative who has lost an election or a minister who is no longer a minister is being asked to leave a bungalow. Today where section 2 defines premises as land and building, the question also arises that there may be situations, sir, there may be situations where LNDO or the government of India or the state government has given a long lease to a hospital like Gangaram, to a prestigious institution, and maybe that lease has run out. In those circumstances, is it practical? Is it practical to make such a draconian and such a provision of procedure where the estate officer is bound to finish a trial within 7 days from the date of notice? Sir, I fully appreciate and I accept the stand of the government that government accommodation is expensive, and today even when we continue, there are enough examples in this nation where they continue to stay in the most luxurious situation in a bungalow, in a house, after paying the penalty, because that penalty is far, far lesser than the market rent value. But the question arises, in the same situation, if I give you the example of a hospital, if I give you the example of an orphanage, if I give you an example of a school, should they be put through the rigors of this? This government has given a provision under section 5.2. I can see Honorable Minister saying, but I draw your attention to the Vikas Jain case in the Supreme Court. I draw your attention to the case of Indian Express, where this act had been invoked, and the Supreme Court has repeatedly said, the Delhi High Court has repeatedly said that where an estate officer is not a legal officer, who's not conversant with complicated questions of possession, leasehold rights, adverse possession, is he equipped to hold a trial in 7 days? Sir, recently in Vasant Kunj we saw that a lot of slum dwellers had been evicted by the Forest Department. Without notice, the Lieutenant Governor of Delhi then interfered to say, why is there no notice? So there are situations that a department can go under this act to evict unauthorized occupants. There are two types of unauthorized occupants. Occupants who come into the land without no lawful mean, and someone who enters into a premises lawfully, but his authorization ends. That distinction is also made. That distinction is also made in this act. But all I'm requesting, sir, that I am repeatedly saying, in a prestigious project like the Delhi Metro Rail, in a prestigious project of the DDA, in a prestigious government project, it is incumbent upon this government to give any government authority the privileges that are there under this act. But all I ask you is, make a distinction. Make a distinction in this act, because Supreme Court in the same judgment that you're seeking to implement through this act has repeatedly said that these suggestions are with regard to government accommodations. Misuse of government accommodation in Lutyens, Delhi, or for judges and public representatives, it may end up being a very draconian law in other situations where this country is still struggling to give housing to all, where this country is still giving land to hospitals and schools. Thank you, sir.
Sri Meenakshi Lekhi.